thank you for being here. I know it's very early, but it's also very late in a sense for this discussion because it's going to be predominantly about MiCA, at least that's what's been announced. But with MiCA, we are already a bit late because it's already applicable. And first of all, I also want to thank this wonderful opening speech. It's really, it never happens that such a high-level person from the local supervisor opens a crypto conference. So this is absolutely a first, extremely important. And it's not just that, we will also have a workshop with participants from the National Competent Authority later on, so please join that. And perhaps this panel will serve as an inspiration for even more questions during this discussion, I hope. So let's dig straight in. So it was announced that we're going to discuss MiCA, so I would suggest we start with MiCA and see where this conversation takes us. So with this wonderful set of panelists, I think it would be great to start with maybe the Austrian experience with MiCA licensing, and then see what other experiences we have here shared among the panelists. So Georg, if you can share a bit more about what you do and what your experience with MiCA has been so far.
Gladly. I'm the CEO of Validvent. We are in still the licensing stage for becoming a crypto asset service provider for crypto advisory. Now, a quick rundown about Austria and MiCA. It all pretty much started with Bitpanda. Of course, in Austria, Bitpanda is the elephant in the room. Bitpanda is the first unicorn out of Austria. Austria has a very, I would say, touchy history with regarding to fintech and crypto. Why? Remember back in 2010, 2012, when N26 was founded. N26 was founded in Berlin, in Germany, with Austrian founders, and the Austrian founders back then said, well, forget Austria, forget Vienna, forget Central Europe, we go to Germany, we go to Berlin, we set up N26 in Berlin. Now what happened with Bitpanda is, actually we have at least one German founder who moved to Austria to found Bitpanda as a crypto exchange in Austria. And with that, along came with it unicorn status of Bitpanda, and then the financial regulator had a lot to learn with Bitpanda. Bitpanda is now one of the most, I would say, regulated crypto platforms out there worldwide. They have an e-money license, they have a crypto license, they have a BSD, a payment service provider license. So effectively, you can do fiat transactions with Bitpanda. And what happened was that a lot of people at the financial regulator got trained by Bitpanda effectively. They moved to the private sector, they were at Bitpanda, they were at Kraken, and now are moving back. Now we're moving back to Austria, and we're staffing the crypto team at the Austrian financial regulator, with the effect that two things are happening. Now, our own licensing process takes now a very long time, since 7 months now, because the other side, I mean, they could be, be in the audience, right? They are very deep into crypto by themselves. They understand it in and out, and they process licensing processes in and out. So it's a very, very thorough process. And secondly, Bitpanda and this perceived and well-received adoption of crypto in Austria led to the fact that a lot of international crypto platforms are now looking at Austria as a European crypto hub. Most and predominantly, Bybit is now also at the second cusp in Austria, and now others are following. One out is, I can name because it's out in the media already, KuCoin is also now setting up in Austria. So that's a little bit happening. Just to give you a little bit of a rundown on, from my perspective, what is the most important point, and that's why I want to highlight that once again, that the chair of the Bulgarian NCA is having the opening speech here and the workshop later today, that it's all about education and bridging adoption between, let's put it that way, the technical frontiers and everyday usability. And everyday usability is in legal language transferred to law and regulation, or translated to law and regulation. And that is happening, and that we are lingual about it is a very good step, and I think that's the most important point.
Thank you so much for this. And yeah, I will continue by picking something that you just said, which is basically the Austrian experience that is very much based on what were the circumstances, and what companies you had. But that differs, as we very well know, across the EU, across the different member states. So perhaps now we can share more about specific examples that are also based on deciding which NCA to approach currently with MiCA. And I know that Vladimir has some experience with that, particularly with drafting white papers. So I know that you chose the Dutch, correct me if I'm wrong.
They don't charge any fees.
So that was the, okay, if we can create like a top 3 reasons why you choose an NCA currently, what would that be? So don't charge fees.
They don't read the white papers and just publish them.
Okay.
And they speak English.
Okay. So anything you would want to add when choosing?
I mean, speaking English is amazing, of course. I add that. Second is, I mean, being Web3 native, right? I mean, understanding what you actually, I don't know whether they read it or not, but at least, pretend to understand what you're handing in was the second point. And the third point is, being responsive after all, right? I mean, look at the Germans, don't shouting out anybody, but if you file something or send an email to BaFin, you'll get an answer by 2028, I guess. I think that's one of the most important ones.
Ellie, anything you would want to... Like picking an NCA doesn't have to be necessarily for publishing a white paper, but also for like CASP licensing. What would be the top 3 criteria you would be looking?
I think I agree with probably both of you guys. Speaking English is quite important. I think probably my second would be a degree of pragmatism from a regulator. So some regulators are more pragmatic than others. And some have been in the crypto game longer than others. So I'm just going to pick Malta as an example, right? Malta had a little bit of bad press recently because apparently they're being a little bit too nice to crypto firms.
We can't have nice things.
But when you look at the Maltese regulator, they've actually been in crypto for a long time. They had a regime for a while. They really, they understand it. They have people inside who really know what they're doing. So I think that makes the whole process of actually dealing with them much easier, much cleaner, much simpler. And that's why a lot of firms are choosing them. I don't think that their standards are necessarily any lower. And I think that the sort of second point that Georg made, which I think is really important if you're running any kind of licensing process or you're a business wanting to do something in a regulated space, is communication and timeframes. I mean, like, how are you supposed to stand up a business if you don't know when the regulator's going to ever respond to you, or if they're going to take 18 months to approve your license? So I'm going to make one more comment on that because I spent a long time living in London in the UK, and I've also the last 3 years been working with a lot of UK firms. So much as I love the FCA in the UK, I think one area where they've been really called out by the industry there, in direct contrast to MiCA, is the licensing process. So there isn't a proper licensing process yet for crypto firms, but you can get this kind of anti-money laundering registration, right? And in order to get one of these registrations takes, I don't know, about 18 to 24 months. And something like, I can't remember the exact percentage, but like 83 to 85% of applications are declined. So this has been a massive sticking point in the UK because it's just, obviously the industry there has felt that like the FCA don't really want to license anyone. That's going to change, but that's the kind of regulatory approach you don't want, right? Spend a lot of money, take a lot of time, and in the end you're like, oh, you've got nothing. So yeah, I think there's a whole spectrum that you'll see, even in the EU, but I think also looking at other jurisdictions, you also really see quite a spectrum of approaches to this kind of thing.
True, yes. So something that I'm asking this question with a very specific idea in mind because it's currently one of the hottest questions in Europe. I think most crypto asset service provider wannabes have already answered this for themselves, but some are still picking and choosing a jurisdiction where to license themselves. So, and particularly right now it's very important because we also obviously need to consider how to get the license, how to passport it in the more efficient way. But then again, it's also going to be the main supervisor. So in a sense, that's something that needs to be acknowledged, particularly because now that the licensing process is ongoing, it's going to finish, at least like the most intense part will finish soon, and then there's going to be the opportunity for NCAs to go more into the details, such as, for example, what is sufficiently decentralized, what is DeFi, and what is outside of MiCA. So this is also something that I want to discuss with you, and I'll start with Vladimir.
Yeah, just wanted to clarify that this was a joke. We like the Dutch authority. And we chose them because of their experience. And they asked questions, they read the white paper. But yeah, going back to sufficiently decentralized, and I guess this is a question, what is DeFi and how is DeFi regulated under the EU regulatory framework? And I would start by saying first, I think, and this is my firm belief, that like staking and liquid staking should be outside of this because they are not finance. You are paying for an IT infrastructure service. This is not finance, so you cannot call it decentralized finance. Then we go into lending. Lending is currently outside the scope of MiCA, so if the service is not regulated, I guess if the way you provide it, the shape or form, whether it's sufficiently decentralized, it doesn't matter because the service itself is not regulated. Then we go to token swaps, like Uniswap, for example, not pointing fingers. And it becomes tricky. It becomes more tricky because then we get into further discussions. How is this provided? What is the backbone? What is infrastructure? What is the client-facing thing? And we might end up with the most earthbound thing, which is the interface. Whether the interface is charging fees, whether it's a passive or an active interface that just shows information or actually helps the transaction happen in the real world, get broadcasted, get picked by RPC nodes or whatnot. Like whether you're charging fees, how are you charging those fees, with custody, without custody. There are many nuances, but it can get murky there. Like you might need a license if you're doing token swaps. And then I guess we go into the votes or yield farming. Those are, I would say it's difficult to fit those into the framework of MiCA, even like portfolio management, maybe custody, because I mean, they are managed on a consolidated basis. They might be another form of security or like collective investment schemes and alternative funds, whatever, but they are definitely not fitting neatly into MiCA unless with the custody. So I guess it's interesting. I don't think we have a clear answer right now. It's still a developing field. The thing is, even if you provide a service that is like regulated, like token swaps, which is the most clear example, if you provide it in a sufficiently decentralized manner without an intermediary, if that is even possible, I guess then you are outside the scope of MiCA. And I guess it is possible. Like if you think an example, we are exchanging tokens, me and you. If we do an atomic swap, there is no person in the middle. So whoever wrote the software or prepared our transactions, whatever, maybe even charging some fees, I would say they just gave us some software which facilitated our trading. They were not providing a regulated service. But anything after that, like slippage, MEV protections, you start to adding, it becomes a little less clear. And also there is the question, like, is it a software license? Is it a software as a service? Because software as a service is more likely to get called, this is my personal view, as a regulated service. It's an evolving thing. I think we are yet to see some more clear guidance, especially, what is a sufficiently decentralized? And people are still trying to figure out how to decentralize interfaces, which is really interesting, with IPFS or just running them in a decentralized manner. We'll see.
Yes, thank you for this great overview. It's particularly timely because that's gonna, as I mentioned, that's gonna be the next big thing in Europe, in the EU. And there are already some national competent authorities publishing papers, so we have at least some sort of an understanding of what the train of thought is currently, particularly, as you mentioned, front ends, interfaces, as being the kind of the obvious way to determine whether or not it's centralized or decentralized.
Well, imagine doing a banking service, which is heavily regulated. Like if you run an interface, you're probably also a bank. Like it doesn't matter that.
Yes. But are there any other indications? Georg, I'm looking at you because I know that you're also working quite a lot on taxation. And when it comes to taxation, there might already be some other interpretations.
Yes, I mean, speaking regarding MiCA, speaking regarding financial regulation, I mean, the obvious is that we as lawyers and regulators and builders can trust on financial regulation in the sense that we have a legal text, so form is over substance, let's put it that way. There is a formal indication on whether you are applicable to financial regulation, yes or no. Now, my interpretation is now that the process involves that taxes is driving the financial regulation agenda in Europe and globally. There is one, I would say, example on how that was kicking off. I'm not telling any names, but it was a chief legal from a major foundation talking about DeFi after MiCA was incepted, presenting their tech stack and their setup to all European regulators. So probably maybe the honorable chair of our NCA here in Bulgaria knows which occasion it was. And it was very well understood along the lines, what you were just saying, if it is DeFi, true DeFi, along applicable technology stack, that fundamentally differs from financial regulation, from MiCA. There is the lending exception. There's fundamental infrastructure services like staking and all, I would say, derivatives to staking. That is clear. And then the last question was, I think, from the Italian regulator, and now, where are you taxed? And the answer of that very educated and experienced CLO was, nowhere. And it was obvious to everybody in the room that it probably cannot be because this CLO is on someone's payroll, right? So here we are. And this is the, let's put it that way, true and fair view we have in global taxation as a paradigm example. So that the question now is, and I think that is now driving the agenda a little bit, and that's going forward, is who has, or which intermediary has a significant control and influence over transactions. Smart contract transactions in DeFi, whether they're true DeFi or not true DeFi. I don't want to shout out anybody here, but look at Hyperliquid. I mean, Hyperliquid, I think, is the story a little bit of the last, I would say, couple of months, but Hyperliquid operates a centralized order book. So is that true DeFi? I leave the answer to all of you. And here we are, right? So do we have to regulate Hyperliquid? Again, maybe we take this to the workshop later on. And I think that is now a little bit driving, I mean, and now in taxes, I mean, taxes are subject to national jurisdictions anyway, but in international crypto tax reporting, the OECD is now clearly stating if there is a party who has a significant control over the transfer of funds, over transaction processing, that entity is required to report all transactions to the national tax authority. So that is pretty straightforward. So I'd be interested to see on who's the reporting party within the Hyperliquid ecosystem. I think I have an idea on who's that going to be, but that's again maybe subject to the workshop later on. But I think that is driving then the agenda. And it's getting even more interesting on where we are with regarding to infrastructure services, regarding staking, right? And then with regard to, I would say, loopholes, I mean, in the grand scheme of things, I think it is not completely understandable why lending, like lending against a counterparty and not decentralized lending, is not covered by MiCA, but I can leave that open for discussion. It's just my personal view. I think that is the big picture here, and that's where we're going down the road in the next, I would say, 2 or 3 years.
Thank you for this. Any hot opinions about taxation, DeFi, that you would want to add?
Probably not on taxation, which I think is Georg's kind of baby. And I think it's really interesting what you said about the tax analysis actually in some ways driving the actual regulatory analysis. I think that's such a prescient point, and in fact it probably will end up being the basis for how this is regulated in a lot of jurisdictions in the world, if not everywhere. I think I just wanted to add a little bit on kind of what's happening in the UK and the US for the audience, because I think it would be quite interesting for them, because obviously the EU was first in crypto with MiCA. Like the EU is is always a front runner in regulation. It does a good job.
In stifling innovation.
Yeah, but they regulated first, and obviously DeFi is outside the scope of it if it's truly decentralized. So, I think one quite interesting point that I just want to make is that because the EU was the first mover, other jurisdictions have obviously been sitting there and watching what's happening and coming up with their own kind of regulatory frameworks with the benefit of seeing what's happened since MiCA came into force. And I think DeFi is a really interesting space for that because neither the UK nor the US have properly regulated DeFi yet. I mean, leaving aside in the US the Securities and Exchange Commission being as aggressive as it has been with enforcement, now it's obviously kind of calmed down. The DeFi regimes in the EU and the UK are being written right now. Right? In the UK, the FCA issued a discussion paper. It's been consulting with people behind the scenes and also done some public consultations on, with the industry, with actually DeFi projects. In the US, as we know, there's a huge amount of work going on the market structure regime. So what a disclosure is going to look like, what a crypto issuance is going to look like, how an intermediary is going to be regulated. And DeFi isn't directly included in that. But the couple of interesting things that have happened there in the last few months is, first, Trump's presidential working group actually issued its report on crypto regulation in July. It is really worth a read, just the summary of it, if nothing else, for people who are interested, because what that report says will end up somehow being implemented in the US, I think. And they do talk about DeFi, and they go I think they go further, but you can tell me if you disagree, than the actual draft legislation in front of Senate does, in that they say, we want DeFi to actually be a part of the financial system. Mm-hmm. We want to ensure people can have self-custodial wallets. We want to make this part of finance somehow, without too much detail on how that will happen, right? So that's being left to the SEC and the CFTC, but there's a lot of consultation and a lot of work being done behind the scenes off the back of that, right? So that's actually quite a big thing. And the other thing that I think is worth watching for its impact on DeFi is, a few days ago you would have seen the US and the UK announced a joint task force on capital markets. No one knows the detail of this. But what I think will happen is that they will try and harmonize these regimes and sort of create a bridge between two of the biggest financial services markets in the world. And DeFi will definitely have a role to play in this. So I don't know what your thoughts are on it.
Yeah, no, I agree. And I think in the US there was like something which said that DeFi interfaces had to rat on their clients. And this was repealed in the US as far as I know. This was a gift that kept giving from the previous administration. And thank God it's gone now. And I know there is a lot of policy work going on in the US from some of the biggest VCs like A16Z. They are pushing for a DeFi safe harbor, actually. And they want to make sure that first, developers are protected. They are not scared after what happened with Tornado Cash. They want to make sure that if you're a developer, you're just writing code, you're not going to go in jail. And the other one is they want to make sure that if it's just an interface or just something helping, the transactions happen, potentially you're not on the hook. There are different ways to regulate crypto, but I guess regulating or targeting interfaces is just the low-hanging fruit. It's just the easiest way, but it doesn't mean it's the best way. Like, there are other ways to target the up level and whatnot.
Maybe you can share some of those other ways?
I don't think we have enough time.
Okay. Control keys, sir. Control keys. Who has the control keys?
Yeah, most of the smart contracts, I guess, nowadays, they're not ossified. Like, if you think about it, probably some developers have way more control and influence than they would like to admit. The other one is, if you are saying you're sufficiently decentralized, if I was to think about it in an anecdotal way, like, if the website goes down, who do I call? So there is always someone that picks up the phone and makes the thing go back online.
By the way, you also have the chance to ask questions to this wonderful panel by scanning the code. Yeah, this is how we're doing this year, and then I'm going to read them out. Filter them, of course, so don't get too crazy, and read them out at the end. But basically what we're also touching upon here is something quite interesting, which is interpretation of DeFi, interpretation in general, interpretation of services of control, governance, all those things. So would you say, and this is a bit of maybe a spicy question currently, but would a centralized supervision solve that? What do you think? Because, and there is a reason why I'm asking, and I'm looking at you, Georg, because you're at least from the same country, I wouldn't say representative, but the same country of one of the 3 authors of a recent paper by 3 supervisors calling for a centralized control of significant CASPs. Austria, France, and Italy. So this is currently a discussion, but what's your take? Would that solve it?
Yeah, I mean, if we talk platform business, probably yes, and would be maybe also more efficient, right? We are talking the 10 biggest platforms in the world. That probably is, in terms of resources, a reasonable approach. And by the way, I can just speak for the Austrians now. It is the opinion of the Austrian regulator, not the opinion of the Austrian government. And it's the Austrian government who represents Austria in the European Council, not the Austrian regulator. So that is also an important footnote here. So this is really a regulator's game here. What's interesting, just as a side note, there is just, because we had the Draghi report just recently, everything which is coming from Europe tends to be a lot in terms of paperwork, right? And I think what all 3 regulators are acknowledging here is that at some point there needs to be a stop, right? A backstop in terms of, we have level 1, we have the regulation text. And there are tons of papers on level 2, on RGSs, on any form of guidances in the MiCA rule book, which just makes MiCA to an enormous animal to read and to digest, even for the regulator. And acknowledging that and putting that to a central level is just reasonable and makes it efficient for all parties involved. So that part, I think we can agree on everything. With regard to DeFi, we just need to be aware of where's the pretty straightforward determination. What is true DeFi and what is DeFi in name only? And everything what is out of DeFi is basically not regulated or not to be regulated. We never ever gonna regulate Bitcoin, right? I mean, everybody in here will subscribe that immediately. So, and everything what is happening with Bitcoin and in Bitcoin is not to be regulated, because Bitcoin is a fundamental question of freedom in a globalized world. And I think that's the question here. But as soon as we are starting towards providing financial integrated services, aka financial services which are not decentralized in the sense as we adhere to the Bitcoin principles peer-to-peer. We are not talking technology anymore, we are talking an intermediate business, then that should be regulated, and I think that is the question, and I think the US is now taking here a sensible step along that route, and it's very good that Tornado Cash is now pushing that forward. So nobody should send Satoshi Nakamoto for putting Bitcoin and the Bitcoin code out there to jail, but of course we need to understand everybody who is building businesses on Bitcoin and builds effectively a Web2 or a platform-related business model has to be regulated after all. I think that is the clear outline here.
I see you have the urge to add something, or was it?
Yeah, I mean, I have a stronger view.
Go on, we love stronger views.
I mean, we were not able to scare business away with MiCA, so now let's create a new agency in Paris or Frankfurt, hire some more people to basically do some more supervision. I mean, this is going to invite business in Europe, and we're going to flourish. If you look at the trading volumes on exchanges in Europe, it's extremely low compared to other jurisdictions. Like, imagine people still wanted to do business in the US with the hostile Gary Gensler there and not come to Europe. Like, how bad it can be. It's, and you want to create central supervision. Like, and also, have you tried to create a startup in Germany? To do your seed round, you would need to go to a notary and spend hundreds of euro on signatures, and it would take you like 18 months or something. Like, this is not how you create startup culture. This is not how you grow businesses here. This is not how you, I mean, and then they adopted the AI Act and whatnot. Like, it feels like we're shooting ourselves in the foot constantly with a machine gun.
Just to add, yeah, so the Frankfurt agency is focused on, anti-money laundering. There isn't going to be a new agency focused on CASPs, don't worry. It already exists. It's in Paris. But yeah, so sorry, go on.
No, I was going to say, I broadly agree with you, Vlad, but but I'm just going to say, you know, Europe does like paperwork. It's a different legal system. I come from a common law, I mean, I'm Bulgarian, but I actually studied common law, right? So the common law system is much less paperwork heavy, just even the laws themselves and the way that it functions. And it is much easier to set up a company in the UK or the US. You can do it in a day. Right, so I think that's completely fair. But maybe one reason why they wanted to create this agency is when you look across Europe, people who are not European, they come to Europe and they will come and get a license and go to a regulator, and they think everywhere, you know, every regulator in every country is the same, and it doesn't matter which one they go to. And some crypto projects, as we discussed yesterday, have been stung exactly by this, right, by going to the wrong regulator. So it shows that there is actually inconsistency in the approach across Europe between different regulators. And actually, if you're trying to run a European business across lots of jurisdictions, that's actually quite costly, right? We're not as harmonized as we really want to be. And I'm not sure how efficient that is for the capital markets in Europe, for the economy in Europe generally. So I think that's my sort of...
Yeah, but on the other hand, like you really need forum shopping in the European Union. And I'll tell you why. This is a good thing. This is competition, basically. It's, they're going in Malta, all of them. Yeah, okay, well, the regulator is friendly. They have experience, by the way. It's not just that they're very friendly. And there are good reasons for that. I mean, if they don't go to Malta, they would go to Panama and the Cayman Islands. So we're competing with Cayman Islands and BVI and Panama with zero tax rates there and with very light regulation compared to MiCA. How are we going to attract business? I mean, of course, if someone wants to service the EU market, they're going to go the easiest way. Like, this is how companies do business. Like, it's almost mandatory, if I'm a director of a CASP, it's almost mandatory because I have fiduciary duties to choose the most lenient regulator.
Great. I'll now pick some questions so they don't get unanswered. I'll go with the top voted one. Yes, you can also vote on questions, so you can, yes.
Arbitrage.
Yes. One of the MiCA recitals states that the issuer is the entity that has control over the creation of the crypto assets. What is your interpretation on control?
Me? Yeah, sure, I have an opinion on that one.
Yes, of course you do.
I have an opinion on everything.
Share your opinions.
Okay, yeah. Actually, I wouldn't care. It's the short answer. I mean, unless you are issuing like a stable coin. The issuer is not regulated under MiCA. Typically, it's not. I mean, you have to pinpoint who is the issuer in the MiCA white paper, and if you get it wrong, there is liability if you lie. And also, that's, by the way, something interesting when we're choosing about the white paper. If you publish your white paper in Ireland, they make you sign an affidavit that everything you say is true, and there is potential criminal liability. So that's why no one is giving the white papers in Ireland. Yeah. Anyway. It's, yeah, sorry, can you repeat the question?
It was about control, but you can...
Sidetracked, yeah, sidetracked.
Yeah, you can spin off.
Yeah, control, it's a very difficult question. Who pressed the key? And it has different implications. For the European Union, no one cares. For Cayman CASP law, they care because whoever is the issuer and is selling newly issued tokens in an ICO, for example, he has to get a license from SEMA in the Cayman Islands. And it's also interesting if you look at the US perspective, because who is the issuer for securities is a separate topic. So if you try to check who is the issuer, you can get different answers in different jurisdictions. In Europe, it's, I guess, the person who pressed the mint button, literally the, the development company that did this. And most of the projects I've worked with, or the bigger ones, they have a typical setup. This is a Cayman Foundation, ownerless, and they have a BVI subsidiary, and this is how they issue the tokens. And typically, it's the BVI subsidiary that issues those tokens. And this has to be papered properly, because if you just issue the tokens, but it was done on the instruction of someone else, I would say the control shifts to the person who told you press the mint button. It depends.
Of course, it depends. It's a legal panel, after all. If you get anything out of it, it's that it depends. But...
And my free advice is get paid consultation.
Two things. Anything else that you would want to add about control and about issuance? No pressure?
No, the only thing I'll add is that, you know, Vlad is right, like issuer itself under MiCA doesn't really have any obligations. The only thing you've really got obligations in respect of is the white paper, right? Don't lie in the white paper, that's probably my one thing. Like, make sure that what you say in the white paper is correct. There aren't any obvious lies. And by the way, you also have an obligation to update it, if things change. And no one really knows actually what that means in practice because there's no real guidance on that.
Yeah.
So seek advice on that too, because,
There is an interesting aspect to that. Like, don't lie in the white paper, because actually it's not just the entity that prepared the white paper that is on the hook. It's also the management body. And the management body has an extremely broad definition which covers shadow directors. So if you have like a founder who is way too involved in the independent foundation, they can be liable for the white paper. It's an interesting aspect no one talks about. But yeah, TLDR, don't lie in the white paper.
Great advice. So let me read another one. So we have this we are going back to the supervision. I love it. Why are CASPs discussing jurisdictions such as Lithuania and Austria, but not Bulgaria? What are the main problems with the licensing procedure here? So perhaps we can also talk about more general problems. I would, and again, come to the workshop, which is right after this panel. You can ask all your questions to the lovely representatives from our National Competent Authority. But there is something else that is also quite relevant, and it is, yes, we have MiCA, we have the regulation, but then we have to see an application, this regulation interpreted into national law. So unfortunately in Bulgaria this took longer than anticipated, which is part of the reason why things are moving on also slower, which for a business dynamic such as crypto is usually a bad thing. So this is my part of the answer. I don't know if you want to share. Oh, I see you want to share. Go on.
We also need a website in English language explaining the procedure very clearly and potentially a guidance in English language. I was working for electronic money institutions and payment service providers back then. And after Brexit, we went and tried to get a license in Belgium, big mistake. But why we did that is because there was guidance in English. Literally, they had a fairly well-drafted guidance in English language. So this is what is attracting business from abroad. We really need a web page and guidance in English. Bulgaria is great jurisdiction because of the 10% flat tax rate. Like, that's unbeatable anywhere. So if the tax is not enough, I don't know what it is. Definitely. The other issue, I guess, is right now, I don't know if you have heard this, but a lot of lawyers are crying out. If you try to create a new company in Bulgaria for a foreigner, it's a nightmare. The banks don't want to do that. Some of the banks are asking the foreigner to come in with their passport in a face-to-face meeting, basically to show their passport to open an account. And to open a company in Bulgaria, you need a bank account, even if it is to put €1 inside. You need to come here, show your passport, and then give them the €1 or whatever. It's a nightmare. Like, it's very difficult, and that's why lawyers have to be creative, like create a company and sell it, but then maybe they need a license under the AML regulations and stuff. So there are a lot of things, and also in Bulgaria it's the same. Like, if you start the seed round, you're probably going to need a notary. Imagine going with a notary, reading like all the SPAs and stuff, and some of the notaries are going to say, oh, I'm not working with English language or whatever, we need a certified translator. Like, there are a lot of bureaucratic things that if we sort out, I think the 10% tax rate can make all the difference, and also there is an abundance of talent here.
Mm-hmm.
Yeah, absolutely agree. What Lithuania and Austria did in particular, they published a roadmap back last year already, where they invited applicants or interested parties to do actually roadshow, basically, with the regulator. And that helped a lot. That provided a lot of legal certainty. And if you seek something in building, especially in that sector, it is certainty provided by the regulator. You carve, and that's actually what Lithuania and Austria provided. And that's basically the reason for it. If you look, for example, to Portugal, right? Portugal is more or less also perceived as a little bit of a Web3 hub. There we have the same situation, right? They just published the MiCA implementation law just this summer. And so the Portugal Web3 hub, let's call it that way, is suffering from that as well. And that lack of legal certainty in Portugal is hampering the Portuguese Web3 ecosystem, clearly.
Yeah, I don't have much to add. I agree with all these points. Also because, language is really a barrier here. If you're not Bulgarian, it's a different alphabet, guys. Like, I brought my boyfriend here and he was like lost. Like really, like he had to sign something. He was completely lost, and I had to take him to a notary office. And I think his eyes were like popping out of his head because he'd never seen anything like this before. I mean, and they were very efficient and nice, but it's, you know, it's everything here actually works well. That's the funny thing. Like people are efficient, things actually work well here. But I think if you're coming from abroad, not speaking Bulgarian and not having been exposed to this, it's actually a bit scary, you know. And if you take out the scare factor and you have a clear roadmap, it'll do wonders. I think I have people asking me about Bulgaria and MiCA licenses all the time at the moment, actually, especially the last few months. Like a lot of people. So there is a lot of interest.
Well, if you think about it, we are winning if we are getting CASPs here, because they are going to be paying tax here. Like, why wouldn't you want to have CASPs?
So something that, at least I keep just thinking about it over and over again is, yes, we have this. Obviously, I would love to create, like, that Bulgaria would turn into a crypto hub, that a lot of CASPs would come and register. But I think, yes, we as a country have a lot of work to do, and thank you for this, basically sharing all of this, because this can already be created as a list, to-do list of sorts. But just, yes, something that I had to mention at first, but this does not constitute legal or financial advice. Please don't ever send this recording to a governmental institution saying this very bright group of lawyers said that. This is not official, but we really love this discussion and having more questions from you as well.
Not your lawyer opinions are mine. I don't represent my clients.
There you go. We need to maybe have it printed out on t-shirts. We have a compliance question. I'm very tempted to go into the compliance road here, because we have been kind of not quite mixing, but also mentioning some AML in particular compliance by you mentioning Frankfurt, this new agency that is now being created, that would have quite a strong focus on crypto. And we also had another question on unhosted wallets, so I would kind of merge them and ask, okay, what is happening with quote-unquote unhosted wallets? We have MiCA, that is basically we have DeFi outside, we have the whole topic about like there is no control, so there is not an entity that is in control and responsible. But then we have the transfer of funds regulation, then we have all these other frameworks that are overlapping. And what happens in practice? Georg, I'm looking at you, of course, because you're also very practically involved in this topic.
Yeah, I would say there are three dimensions to self-hosted wallets. First of all, everything which is self-hosted is not regulated, right? So my self-hosted wallets here are nobody's concern. So that's basically it. Second question is on whether those service providers who provide self-hosted wallets, aka our wallet software providers, are to be regulated. Is the second dimension, right? I would say at the moment, my personal opinion, no, because they simply provide software. So that is the most important point. Other than they have control keys, other than they have the functionality to transfer funds and so on and so forth. But the mere, let's put it that way, deployment of a software which provides the user to host wallets self-hosted, basically, on a self-hosted basis, is not regulated. So I think that is the second dimension. And the third dimension is coming now from reporting requirements, be it taxation or be it AML, that with the transfer funds regulations, with the travel rule, basically also transactions with regard to self-hosted wallets fall under the realm of reporting and compliance obligations, be it under tax reporting or be it under AML checks. I give one very basic advice to everybody who wants to have a safe, let's put it that way, on and off-ramp rail to centralized exchanges. Do your centralized exchange and yourself a favor by dedicating one self-hosted wallet you have on your mobile or wherever, which you permanently use with regard to an on-ramp or an off-ramp vis-a-vis a centralized exchange. Makes your life easier and makes the life of the centralized exchange way easier, because the self-hosted wallet check and transfer funds regulations obligations are way easier in order to comply with. So maybe these are the broad three dimensions along these questions, but the big question, of course, is as long as it's self-hosted, we should fight for this. This is a fundamental right of privacy. We had it yesterday, that everything was happening self-hosted, like cash in your pocket, isn't nobody else's concern. I think that's where we have to draw a line and be very clear about it. Everything else, is up to debate, and I think we touched it already, but I would cover it up with the 3 dimensions.
A wild Duck 8 question just appeared, so I'm going to throw it at you at that exact moment. How would Duck 8 actually change? Would it change anything?
I mean, I have a strong view on that as well, right? Duck 8 and the crypto asset reporting framework effectively provides a common reporting standard for crypto. What does that mean? That basically means that there is a list of integrations being added to your tax authority, right? Because every reporting crypto asset service provider has to report the balances of every user as of end of year date. And that effectively, and that's a one strong message I want to bring forward here, is leads up until 2030, where all jurisdictions worldwide, and I think it's only North Korea and Iran who won't be participating, all the others will be participating. So also BVI, Cayman, all the other jurisdictions well known for that. So that effectively leads to the point that we're gonna have a crypto integration register, right? Be aware of that. That's very fundamental, and that is a very strong message here that effectively gonna be coming from 2030 onwards.
Very important, yes. Keep those things in mind. It's not just MiCA. So we have to wrap this up. And usually last year I was ending all the panels with, what are you most optimistic about? But this is a new year, so now I will end it with, what keeps you up at night? What you worry about the most currently? Is it Duck 8 in your case? I'll start with you.
No, it is the fight for privacy, I would say. We have the fight for privacy in a lot of domains, not only taxation reporting. We have it alongside DeFi, true DeFi services. We have it with regards to the IAC. We have it with regards to deployment of software, smart contracts. We have it everywhere. So the fundamental right to privacy on-chain and in the digital realm, I think, is the most important fight of our age.
Privacy, yes, is something that we at the EUCI also work quite closely on. So, and Georg has been a great supporter of this. So I definitely add privacy on top of my list, but let's go on with more strong opinions here. I can sense them boiling.
The legal backlog keeps me up at night.
And something more, I don't know, macro-oriented?
Yeah, more macro. Is the ever-evolving legislation, and that it is extremely difficult to catch up to the point that I think at some point it's almost going to be impossible. Like it's so hard already, it doesn't need to get harder. Like we need to find a way to make it easier, maybe harmonize between different jurisdictions or something, but otherwise it becomes almost unmanageable at some point. Like, and so many legal frameworks, I mean, we need well-devised laws that solve problems, not create administrative burden or 70 pages white papers, which you just do to basically cover your own risks so that you don't get sued. Like, if you look at the white papers, everyone copy-pastes all the same risks, and they exclude liability for that. How is that helping the consumer? And is the consumer reading that? Like, we really need something that is well thought through and is working, not creating more work. And I guess that's what keeps me up at night, trying to stay on top of things, which is very difficult, and making sure my clients make money.
The story of the crypto lawyer's life, just, there's too much going on. Ellie, anything, what apart from your boyfriend getting lost in Bulgaria?
I would agree with both of you guys. I mean, big picture, I think privacy is really important, and it is going to be data, actually. You know, your data is going to be the battle of the future, because when you add what's going on in crypto to what's going on in the AI world and how data feeds into that, I think we have a big fight on that coming up. Short term, you know, what keeps me up at night, I literally, to try and just keep up with what's going on in crypto, in the market, regulatory developments, legal developments, I'm sitting there like scrolling through my phone, through like Telegram and LinkedIn like 2 hours a night. I realized at one point, I was like, this is so inefficient, because everyone because there's nowhere to find anything other than those channels, right? People will put something on Telegram or someone will put something on LinkedIn. That's actually how you keep up with what's going on, and it's constant. I don't have time to, there's so many discussion papers and documents and pieces of legislation that have come out in the last 12 months, particularly for lawyers. I don't even have, I barely have time to read the summaries of these things. Like, I'm like, oh, there's another 180-page document tomorrow. So that's, I think one thing that I'm actually quite excited about, though, I'm going to end on that note, is, which also keeps me up at night, but in a good way, is I think capital markets, like traditional capital markets, is in a lot of ways broken, right? Like it's very manual. We're still relying on these rules from like 100 years ago, in fact, almost 100 years ago. Everything is very paper-based. I'm not sure that really, to your point, Vlad, like the current rules actually protect, and I'm not sure if they're appropriate for your kind of Gen Z investor, right? And I'm not sure they're doing their job anymore. So I think what is really interesting, which I can see happening, is the capital markets is going on chain. And that's going to be, that could really open up like a lot of markets, a lot of opportunities in the next 5 to 10 years. I think that's a super exciting thing, actually.
Yeah, and there would be no more like cases like Madoff or cases like Naked Shorts with GameStop and stuff like this. Because if everything is on chain, it's verifiable. Like you invest, there is a record there. Like it's not like, don't worry, your money are being invested, zero risk, it's all good, just don't ask questions or...
Don't Google us. Yeah, that's a brilliant note to end this. Let's not forget why we're in this space, why we're building on blockchain, because it's recreating the system in a better way, let's hope. And with this, I want to thank this lovely group of lawyers, which is a sentence that you don't hear often, I guess. And invite you all to continue the legal discussion in the next room, starting in 14 minutes, for those of you who are interested in this topic. And for the rest, enjoy this, and yes, don't forget to check all those Telegram channels and what is going on and what's the new taxation regime. And if that doesn't work for you, you can always follow the EUCI. We do this kind of summed up versions, or just follow any of those brilliant minds here. So
and don't open question about Zoom links.
Never. Thank you for this, and enjoy the rest of the conference.